Hello Esmeralda, my name is Isabel and I'm here to talk to you about your boundary dispute, Anakin, and the option of using mediation as an alternative to litigation. First, I would like to explain to you the mediation process and the procedure which is involved. When you enter into the mediation process, the first stage is the opening phase. You and Anakin will both be present at this meeting, and the mediator will introduce himself and outline the dispute between Anakin and you. The mediator will then set out certain rules. These include that the mediator is impartial and that each party has the opportunity to present their own case and to speak freely about any matter that they wish. The other party must not interrupt whilst the other party is speaking. If they have an area of contention, then they should write it down and they'll have the opportunity to raise it when it is their turn to speak. The parties must avoid using aggressive and rude speech whilst in the mediation process, and the parties will also be told that the entire proceedings are confidential and that the meeting is without prejudice. If a settlement is not reached, then the parties cannot use anything that they have learned from the mediation and pass it on to any third party. This is the same for the mediator, as they cannot repeat anything unless they have the express permission to do so. This process is also voluntary, so any party can leave when they wish. However, it is likely that the mediator will want 5 minutes with that party to try and discuss the problems that they are having and to try and resolve them so that they do not leave the mediation process. If no agreement is reached, then the parties are not bound by what they have discussed. It is only binding when the agreement is drawn up and the parties have signed it. The next stage is the exploration phase. Here the parties will either go into private meeting rooms with the mediator, or they might be willing to have a joint meeting where they will be able to present their case. After this, the next stage is the negotiation phase. This is where parties will consider putting proposals forward for the settlement. Here, the mediator will only guide the parties, he will not come up with the settlements. Therefore, it means that the parties have full control, they can decide what they want to put forward as the settlement. It is likely that the minor issues will be dealt with first, such as the loud music. This is to encourage the parties to solve the major issues later on. The final stage of mediation is the settlement or the closing phase. By this stage, a settlement should have been reached between the parties, and the mediator will confirm the agreement reached and will draw up the settlement agreement. If lawyers are involved, then the mediator will ask the lawyers to draw this up. The mediator will not leave the mediation until the agreement is signed by both parties. If no settlement is reached, the mediator should make a full account of the reasons why it did not result in a settlement. The mediator will then convene a joint meeting, and this is where he will confirm whatever outcome is reached. So that is the mediation process. Next, I will outline the general advantages of mediation for you to consider. First advantage of mediation is that the parties retain full control throughout the process. This is because agreements are reached between the parties instead of the court imposing something on the parties. The mediator is also impartial. So they are professionally experienced, they have experience of dealing with this type of dispute for a long time. So they do not take sides or pick a winner, they will instead concentrate on what the best way forward is for each party. Mediation also reopens communications between parties. This is because often neither party understands why the other feels as it does. Mediation is also speedy and cost effective. This is one of the main advantages of mediation. This is because a large majority of disputes in mediation will be fully resolved in a day. This is totally different to courts, where it will last quite a long time. It is also a fraction of the cost of court proceedings. For example, in Wilkinson and the estate of Brian Wilkinson, farmer, the costs which were incurred in that case were £240,000. The parties can agree rights which the courts can't. This is because the courts will try to find the legal boundary. However, the parties in mediation can find the best boundary for both of you. I'm now going to outline the advantages which will specifically benefit you in your particular case. Firstly, if you go on to sell your property, then you have a general duty to disclose to the purchaser of the property or the potential buyer that you have had a dispute with your neighbour. Now this would be a disadvantage to you because this could make the value of your property decrease. Therefore it's best to mediate so that you can resolve the dispute between you and Anakin. The costs of mediation compared to litigation are clearly an advantage to you. This is because, as I have already stated, it is very costly, and because determining the legal boundary between properties is difficult. Although it's not as much as the example I gave before, another case which the costs were very high was Huntley and Arms, where it involved 14 inches and was £80,000. Mediation may also improve your relationship with Anakin. This is because you'll start discussing your issues in a healthy environment, and this will benefit you because I can see from the facts you have given me that you used to help Anakin out when he had his accident, and because of this dispute you no longer speak to each other anymore. Throughout the mediation process, you're also maintaining in control. You can decide what works for you both and come to an agreement which you're both happy with. You'll also be able to determine the best boundary line and arrangement for you. Instead of there being a winner and one loser, as with litigation, you'll both build up winners because you've reached an agreement that you've both come up with and you're both happy with. All in all, you won't lose anything from trying mediation, because the information which is discussed during the mediation process cannot be used in court. Now that we have been through the mediation process, I've written up a draft mediation agreement. This agreement states that you agree to the following: that you will try and ensure that your dog does not leave excrement on Anakin's skydiver's garden, and that if it does, you will clean it up as is reasonably possible. You've also agreed that when your friends and relatives come to visit you, that you ensure that they will park as close to your property so they do not park across Anakin's driveway. In addition to this, Anakin has agreed that he will not listen to his music at an unreasonable volume, and where possible he will make sure that the window is down so it doesn't disrupt you that much. He's also agreed that he will put the lid down when he puts out his rubbish. Finally, if these are complied with, then the fence will not be put up. However, if one is unreasonably breached in this agreement, then Anakin will put up the fence, but you have both agreed that it will be in the middle of where you both think the boundary is, which is, as it is 30 centimetres, it will be 15 centimetres from both of your properties. It is beneficial for you to sign this agreement because you've come up with a fair agreement. You're both happy to put the fence in the middle. If Anakin does not comply with this agreement, then you will be able to enforce it contractually or use further mediation. I hope this helps, Esmeralda. Let me know if you need any more.